This is António Campinos, the president of the European Patent Office, and you are listening to IP Fridays.
Hello and welcome to this episode of IP Fridays. Our names are Ken Suzan and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
I am Rolf Claessen, and my co-host Ken Suzan and I are welcoming you to episode 161 of our podcast IP Fridays. Today's interview guest is António Campinos, who is the president of the European Patent Office. We talk about the Draghi report, patent quality, the Unified Patent Court, AI, validation in non-European countries, and many other topics. But before we jump into this interview, I have news for you. Our podcast IP Fridays has been named as one of the best intellectual property podcasts in the world by FeedSpot. You can find the link in the show notes. The European Patent Office has published the Patent Index 2024. The US, Germany, and Japan are the strongest patent filers at the European Patent Office, followed by China, South Korea, and France. The biggest three patent filers are all from Asia, namely Samsung, Huawei, and LG. The strongest US filer is Qualcomm in the 4th place, and the biggest German filer is Siemens at 6th place. And now for an unusual decision of a patent judge. Magistrate Judge Valerie Figueredo of the US District Court for the Southern District of New York has ordered a patent litigator, Bill Ramey, to pay the attorney fees of the opponent Google. She said that the attorney failed to conduct an adequate pre-suit investigation that would have uncovered information demonstrating that the patent infringement claim lacked merit, and also unreasonably continued pursuing the claim despite notice from the defendant that the claim lacked a colorable basis. Google was represented by Barnes & Thornburg. The EU IPO has published CP15 Common Communication Comparison of Goods and Services, treatment of terms lacking clarity and precision and common interpretation of the canon criteria and other factors. It enhances the consistency in the comparison of goods and services across the EU. Terms lacking clarity and precision must not be excluded from the outset, but should be interpreted based on their natural and literal meaning, considering the NIS classification, and such terms cannot be interpreted in the way that benefits the trademark owner. So that's an important point of this communication. If identical or synonymous unclear terms appear in both the earlier and the contested mark, they are deemed identical. Additionally, a single factor, such as intended purpose, relevant public, or distribution channels, may be sufficient to establish similarity. By introducing common definitions and interpretations of the key comparison criteria, CP15 promotes transparency, legal certainty, and harmonization decision-making among IP offices. I have published a book, Markenrecht einfach, with the publisher Frankfurter Allgemeine Buch on 5th of March 2025. Today, I learned that my book entered the best-selling list of Manager magazine for business books at 8th place. I'm very grateful for all the people who helped me with this huge success. And now let's jump into the interview with António Campinos.
Today's guest is António Campinos. He is the president of the European Patent Office since 1st of July 2018. And before that, he was the president, or he was heading the EU IPO. Thank you very much for being here, António.
Thank you, Rolf and I.
Let's start with the Draghi report. It's exciting to me. 2025 is set to be a year of milestones and challenges for Europe, especially when it comes to technology and patents. So let's kick things off by looking at the Draghi report. It's a hot topic right now, presented to the European Commission in September. This report, to some degree, outlines a roadmap for Europe. At its core, the Draghi report highlights Europe's need to close its innovation gap, something we are seeing as European innovation lags behind powerhouses like the US or China. What lessons do you think Europe can learn from this to accelerate its innovation trajectory?
As you said, Rolf, I think that it's clear that the Draghi report is a wake-up call for Europe and a much-needed one. If I had to summarize it in a few words, I would say that Draghi tells us that Europe must address excessive regulation. Excessive regulation is stifling the internal market, and it's weakening, I do believe, our capacity to generate economic players on par with those in the US and China. Let's think about tech industry, for instance. And there, in any case, I'm not only talking about these big tech companies, but I'm also talking about startups that need to scale up. It might come as a surprise to many, but when we look at the numbers, Europe in the past 5 years has generated more startups than the US. But then what actually happens is that too many of these startups decide to relocate their headquarters abroad, and many you have understood in the US. Why? Well, clearly because of the non-availability of scaling up funding, at least to the extent needed. And then, of course, because in many ways the internal market is still very much fragmented. And with fragmentation comes bureaucracy, and that bureaucracy particularly affects micro entities and startups. There's another way to answer to your question, and that relates very much again to what Draghi tells us. Draghi tells us if Europe wants to keep its social model with our welfare and redistribution policies, Europe needs to be more productive, needs to be more competitive. And of course, for that to happen, not only we need to invest more in innovation, but we need to be smarter when we invest in innovation. We all agree that breakthrough technologies is crucial for accelerating Europe's green and digital revolution. Yes, but where? So I think that it's time to apply a lens that will give us in Europe more granularity and really help us in identifying where Europe leads or lags behind in key underlying technologies. To give you an example, Rob, Europe is well known for its strength in transportation technologies, mechanical engineering, and chemistry. We are also at the forefront on clean tech patenting. And here our past research shows a clear European lead in hydrogen, in power grids, or plastics recycling. However, if we look into the numbers, we will see that batteries remain an area of concern. And there in batteries technologies, we are lagging behind Asia, and it is a crucial sustainable technology, as everybody knows. This week, we have launched our patent index, and when we read our patent index, it's clear that we are trailing behind both the US and China, for instance, in computer technology. Since 2019, our filings in AI patent filings in NI have grown annually around 30%, showing clearly that this technology is growing very, very, very fast. And there again, we need to catch up. When we look at the data for international patent families, we also see that we are being outpaced by the US in biotech and pharmaceuticals. So, Rolf, to answer to your question in a very simple manner, if we want to accelerate our innovation trajectory, we must invest more, but as importantly, we need to invest smarter.
Yes, and one important thing, you talked about fragmentation. That's an interesting topic. So when it comes to the Draghi report and Draghi in your area of work, the patents, what role can the European patent system play in cutting through the fragmentation and the complexity we are facing?
Okay, I think that there's two different ways to answer to your question. At least there's two different perspectives. The first one is a classical legal perspective. And there, let me tell you what we've been doing. First, we have launched a convergence program. And this convergence program, we launched it with our member states in the frame of the European Patent Network. And this program aims to align legal practices in Europe by simply establishing common practices. In the past few years, with our member states, we agreed on at least a dozen different common practice in very important actually areas of the patent granting process, such as the computer implemented inventions or artificial intelligence. And this year we'll be looking at third-party observations and also other matters. It is also important to bear in mind that many applicants file in different jurisdictions. So a common practice, you will agree with me, reduces the complexity and bureaucracy when you interact with these different administrations. And again, this is very important for our micro entities, for our medium-sized companies, which, by the way, are the vast majority of our applicants. Since this kind of bureaucracy affects far more, as I said, the micro entities, the research center, the universities, than large applicants. And of course, when we talk about how to cut through fragmentation and complexity, I could not mention the UPP UPC. After more than 50 years, close to 70 years actually, of discussion, it's finally possible in Europe to obtain uniform protection in 18 of our member states through, as we like to say, a single application, a single attorney, one set of renewal fees in the same currency, by the way, and with only one responsible court, the Unified Patent Court. We are totally convinced that the UPP UPC is really a stepping stone towards the creation of a single market for technologies. And having said so, Rolf, why not even perhaps one day when all member states will have joined the system to look beyond just the European Union? Why not? When there's a political will, there's always a legal way, even if it is a complex legal way. The other way or the other angle in looking at your question is linked in reducing the complexity and in understanding data, or if you prefer, it's the journey in transforming data into knowledge and the journey in transforming knowledge into business intelligence. Now, for decades, the EPO has made available all its public data to access and search free of charge. Of course, I'm referring to EspaceNet, 115 million patent documents available in 27 languages through automatic translation. I don't know, maybe people do not know, but I think this number is a very important number and talks a lot to itself, which is last year alone, EspaceNet was visited, Rolf, are you seated?
Yeah, okay. 30 million, 50 million.
18 million. Yeah, right. 18 million times just last year.
Wow.
But we don't rest on our laurels. I mean, now what we're doing is that we are working on improving the accessibility and the readability of this huge amount of data. And to do so, we're using the latest technologies such as large language models, LLMs, and natural language processing. Recently, maybe it's important to stress, we have launched the Technology Intelligence Platform. What is that? It's a way to offer data in a completely different way. It allows you to interact actually with this patent data. Why? Because this platform connects patents with applicants, with technologies, and with trends. So you don't need to be an expert on the area to actually try to understand how innovation in a certain field has evolved over time, or even to show which companies are leading in a specific technology area. In simple words, and this platform makes complex patent data accessible, not just, as I was saying, to experts, but to anyone interested in understanding innovation on a more micro level. So researchers, economists, policymakers, medias, businesses, all of them can use this platform to make data-driven decisions or to understand what should be underlying when you make these decisions in ways that were simply not possible before.
Yeah, and you mentioned the accessibility of data. I just want to add, you have a great API that I already used myself to access your data. That's great. And also, I really appreciate your efforts to harmonize patent law in Europe. That's really a very good move forward. You also mentioned the unitary patent. What insights have you gained from its first year, and how can those learnings attract broader participation, both within and outside Europe, especially plaintiffs or defendants, plaintiffs mainly, basically from outside Europe? And just to add to that, what obstacles remain in achieving a truly unified patent vision for Europe?
Well, when we talk about UPC, there's three words that come to my mind. A huge success. Now, today, more than 50,000 requests for unitary protection, more than 700 high-quality decisions rendered by the Unified Patent Court since the launch. And may I underline, because probably that will make other courts blush throughout Europe, each one of these decisions have been taken in less than 6 months, as prescribed by the regulation, by the way. I think that over time, the UPC will continue to gain, I would say, natural traction. More and more applicants will become acquainted with the system. And we expect a rise in the number of applications in the future coming from the US, from China, from Japan, and South Korea. And I think it's important also to highlight the following. And what I'm going to say was, I do remember when we were discussing the package in Brussels, there was this intended purpose of the legislation of making the UPC more attractive to small entities, to micro entities, to medium-sized companies, to research centers and universities. And in fact, when we look at the numbers, SMEs and individual inventors account already for 1/3 of the overall number of unitary requests. So it's an impressive number. It's even more impressive that the classic European patents. Another number which is very, very, very impressive is that 50% of the SMEs are opting for the unitary effect after a patent grant. So these are very, very good numbers, and I look forward to see how we can even further progress there. At the end of the day, Rolf, I would say that, I mean, if you really want to have a truly unified patent vision for Europe, I think that will be achieved, and that's what, again, Draghi and Letta rightly point out, when all EU member states will join the system. And there, from my recent visits, I think that we will be hearing some positive news in the months to come. I understand that for some of our member states, the proposal of the Commission was not good enough in certain legal aspects. Others wanted to test the system, but I think that the system is there, is functioning well. We have the Draghi and Letta report, and I think it's difficult, taking account the geopolitics that we all experience, to stay out of the system. And of course, we will be, thrilled to see other member states, and that will happen joining the system in the months to come.
Yes, I hope so. And some member states already announced their participation, so that's great.
Yeah.
Antonio, before this interview, I had the chance to briefly discuss the history behind the developments of the UPC system with Margot Fröhlinger. In fact, she quoted you saying that there were many fathers of the UPC, but only one mother.
It's true.
You are certainly one of the fathers.
Yeah,
and what can the world learn from the very, very long process of establishing the UPC? What mistakes should be avoided in the future for similar projects?
Difficult question to answer. But what I would say is there any lessons learned? And there are lessons learned. We should be looking towards ourselves in Europe rather than look at the other regions of the world. And as to ourselves and looking into ourselves, I would say, let us not repeat the errors of the past. If you look at history, the long history of the unitary patent and the many failed attempts to create it, and as well the unified jurisdiction, of course, this failure was mainly due to insufficient involvement and support from the relevant stakeholders, from industry, from the patent judges, the patent professionals. And in fact, when you look backwards, only when the Commission started to work with and for, may I say, all stakeholders, the final breakthrough became possible. So I would say, let's learn from that when addressing important patent matters, such as standard essential patents or the SPC, the Supplementary Protection Certificates. Let's take the time to listen carefully to all stakeholders. Let us take the time to examine the facts and evidence. Let us take the time to assess the key actors and to look at their competencies, both organizations and courts alike. And of course, let us look at the good work they are carrying out. So, in this respect, I would like to say that the EPO, of course, welcomes the Commission's withdrawal of the CEP proposal. Why? Because it was controversial. It was controversial among stakeholders. It was controversial about member states. And many, in fact, consider that the proposal, if it would come to an implementation phase, it would, rather than boost innovation, it would stifle innovation in Europe. Having said so, let me be very clear from the matter. We do think at EPO that regarding CEPs, more measures are needed to be taken into consideration. A, to increase transparency, and B, I would say to facilitate licensing and in doing so, striking a fair and better balance between both innovators and implementers. And as far as the SPCs are concerned, it is clear today that there's one important message, which is a message from our member states, from the Council to the Commission, is that stakeholders, they do want matters to be subject to the jurisdiction of the Unified Patent Court. And if we were to adapt, the Commission were to adapt some proposal, I think it could be done. But of course, it would require some adaptations of the proposed institutional setup. But that's perfectly doable in my view.
Yeah, very interesting thoughts, especially also about the standard essential patents. That's a hot topic right now. Let's move to another topic that is on everybody's mind right now, like all people basically, AI. So what are the key challenges that you as an office are facing or might face in the future when it comes to AI or digital transformation in general?
Well, actually, the EPO faces exactly the same challenges that other organizations or entities. When you look at digital transformation, your first challenge is to simplify your legal processes, simplify your legal procedure, simplify your practice in order actually for the digital transformation to bring added value. Too much complex. IT systems do not like too much complexity. So you need to simplify. Excessive bureaucracy in this digital transformation, and I would say it makes even it impossible to happen. So that's the first item. You simplify. The second is that you need to take care of change management, because at the end of the day, what is the purpose of digital transformation? What is the purpose of launching a new tool, a new IT tool? If that tool is not understood, and not being understood, is not therefore used. And three, I would say we need all to think when we are managing that from the outset we will be able to deliver a perfect tool, a perfect databases that will address all the concerns. Rather, you need to think about a viable product. And what I think you need to do is to increase your capacity to improve this viable product as you move forward. And when it comes to AI specifically, I think that the challenge posed by AI have been taken very much upfront from DPO. We said always, human will be in control. Which is basically to say that we have a human-centric approach, which implies that any final decision at EPO will always be taken by humans.
Okay, that's a very important decision. Thank you.
Thank you.
Let's talk about a different topic that was also very hot among the last months or years even, the quality at the EPO.
Yeah.
And the EPO has been known for its high standards in quality, but let's be real, it can't always be easy to keep up with those high expectations from the users, especially as landscape shifts and you're catering to a very wide range of users. of new and expanding markets who have different opinions. So how is the EPO staying ahead of the curve on all of this? In other words, what are the EPO's priorities for maintaining and enhancing the quality?
Okay. Yes. I mean, I think that staying at the top is always tougher than getting there. But before I address this issue, let me maybe start by the start, if I may say. We have to deal with 200,000 applications every year that we receive from every corner of the world. These 200,000 applications, in fact, they correspond to more than 400,000 what we call patent work product, whether you're talking about the search or you're talking about an examination, talking about new position. And there, from the outset, I think that the European Patent Office displays very convincing arguments. Whatever your views are on the quality of work, we display very convincing arguments. This is objective. This is not subjective, what I'm going to tell you. Objective, not subjective, because we know that quality sometimes is a matter of subjectivity as well. Well, first we have highly skilled workforce, 4,000 highly skilled examiners, and plus around 400 formality officers, very skilled themselves too. Second, we have the largest worldwide patent and non-patent collection. I remember 150 million documents on this PassNet. We have very powerful search engines. This PassNet referred to, everybody knows about Epoch, that will be decommissioned this year. We have Ansera, our more recent search engine, extremely powerful. And we are the only office in the world where every single application is reviewed by a division of 3 examiners at the examination phase. And now we have further expanded that to the search stage for even high quality assurance. And this is very important, as you will understand, since more and more the application touch upon different technical fields. So they keep the objective. No, I'm not talking about subject, I'm talking about objectivity. So these 3 elements make us, I think, unique and are very convincing arguments when we discuss about quality. The other element that I would refer is that our search report, and that I think is something where we are unique in the world as well. Our search report contains a preliminary opinion on the patentability of the invention, and this search report, with this preliminary opinion on the patentability of the invention, is delivered in 6 months, or better, is issued, to be more accurate, is issued in 6 months. And with this search report, if you have a positive opinion on the patentability of invention, it will be much easier for you to attract early funding for, I don't know, to build the business case, to build the prototype, to test the markets, where to launch first your technology. So that makes us, again, unique in the world. Now, I also understand and I agree that the opinion of other offices throughout the world might differ from ours. Okay, that's fine. But, Rolf, it's nonetheless true, that the EPO's work products are used in many, if not all, jurisdictions. So we are a benchmark on quality. And in any case, to keep us with, as you say, these high expectations, especially when the landscape shifts with a high range of users in new and expanding markets, like you said, we have increased our quality checks. That's what we did. We increased our quality checks. Our quality checks today, they cover the entire patent granting process, from formalities to positions. We have also, in the past years, tripled the size of the SACEPO, working parties. We interact with users from 40 countries on various topics, from the e-patent process to quality. We also launched something which is unique, that I had the opportunity to launch from the UIPO on the side of trademarks and design. We have launched our stakeholder quality assurance panels, what we call SQAPs. What are the SQAPs? They involve European patent attorneys, they involve our examiners in assessing in a pragmatic manner the quality of our examination for randomly selected application across different technical fields. So why we did that? Because, as I said, there's objective elements to quality, but there's subjective elements to quality, and we wanted to make sure that we would incentivize the bridging the gap between internal and external perception, and that's exactly what the SWAP do, connecting internal expert perception with those of the broader patent attorney community.
Yes, and in this context of quality, some applicants that I talked to remember times when the staff of the applicants were able to meet with examiners in informal meetings personally to discuss general topics that came up, not necessarily specific applications or so. And at the moment, I could think of the topic of, for example, incomplete searches, let's say. These meetings had the goal that the people actually working on the applications had the opportunity to gain a better understanding of the other side, so in both directions, right? And I understand you already had meetings on a high level with applicants. Do you think that these more informal meetings with the staff, these times come back at some point?
Informal meetings, interesting concept. We don't have informal meetings. We have formal meetings, although they can be held informally. But come on, Rolf. I mean, just last year, Steve Rome, or VP1, in charge of the PGP, with the relevant technical teams, so team managers and members of the teams, they met with more than 50 companies. 50 companies, wow. From large applicants to SMEs. So, I mean, we are meeting one-to-one, but in the right setup, I would say. And actually, these meetings are very appreciated by our users. We have also, by the way, introduced company visits to the EPO, so them coming to us. Whether virtually, whether in person, we're in a hybrid manner, and these meetings actually are company-led training sessions on new technology. So they explain to us what are the latest technologies for us to have an understanding where the market is moving towards to. So we have that done, and finally, this year we're about to launch a new concept where we will offer the possibility to our different teams to attend trade fairs or similar concepts, which will allow examiners to connect with multiple companies in one place, multiple companies that sometimes have competitors. So I would like to underline that. I want is our teams to be in one place where they can meet multiple companies, often competitors, not only to understand the latest technologies, but to be able to discuss with all those companies how we can improve the quality of the application, or listening to them how we can improve the quality of our products and of our service.
Okay, thank you very much. That was a very helpful answer, I guess, for the listeners. Let's switch to a different topic, scaling up the mechanisms for sharing the benefits across borders, basically. What else is the EPO doing at the moment to meet the demands of its global users in today's interconnected world? And what is the next in terms of validation agreements?
Yeah, I mean, patent applications are growing worldwide. 15 years ago, we had roughly 1.6 million patent filings presented throughout the world. In 2023, we reached 3 million. And in 10 years from now, who knows, Rolf? But let's have a deeper look into the numbers. When we look at patent families, of course, the number of applications is much lower. Why? Because applicants often file the same patent in multiple jurisdictions, in different national patent offices. So my point is, if the work is of high quality and carried out on time, why redo it? Why do we like to redo it? And actually, this principle is what inspired the founding fathers of DPC to allow the European Patent Office to propose, and then the European Patent Organization and the Ministry Council to authorize or not negotiations on a validation agreement, and ultimately to agree on the final text or not of this validation agreement. So, to the same extent that an applicant can decide to convert a European grant into a national patent, in any or all of our member states. This option now is also possible today in 6 other countries outside Europe. And another validation agreement with Laos is set to come effect just in a few days. And again, we recently signed, and we're very happy with that, a validation agreement with Costa Rica, which is the first country of Latin America or South America to have joined a validation agreement. And what is important to note is that when you take our member states and all these validation countries together, we are talking about a market of 720 million consumers. 720 million consumers. This is a huge technological marketplace, which is open to any of the applicants who interact with us, Rolf. And I think this is a good thing. And hopefully in the near future, we will be able to expand the validation agreements in more countries of Latin America, and we'll come back to that maybe in a next year interview, Rolf.
Yes, it's very exciting to see more and more countries accepting your model, basically, of accepting the search and examination results of your office and to grant patent rights in even outside continental Europe. So that's very exciting for a lot of users to see. Thank you so much for that instrument, basically. So when we come to a close of this interview, finally, if you could deliver one message to users and policymakers and innovators around the world about the European patent system, what would it be?
Well, to our users and potentially the innovators of tomorrow, I would say that we are committed to delivering the highest quality services and products. That's what we do. That's what we do on a daily basis. And when we don't, or when we fail, believe us when we say that we'll make sure to learn from it. So that's the first answer to the question. The second relates to our policymakers. I would say to our policymakers, we have to understand before we act. And this doesn't come from me, actually, Rolf. This is a quote from Michel Barnier, former EU Commissioner for the Internal Market and former Prime Minister of France. We have to understand before we act. That's what I would say to our policymakers.
Yes, very important at the moment with all the politics going on in Europe.
I think so.
Thank you so much for taking your time to be on IP Fridays.
My pleasure. My pleasure.
Thank you so much.
Thank you.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.